I want to warmly welcome all of you, our panelists, but also colleagues and whoever is interested in this very sensitive topic from all over the world. My name is Andrea Mininski-Bigazzi, and I have the pleasure of coordinating privacy rules together with my colleague Alessandro Di Mattia, who's connected here as well. Privacy rules is, for the moment, the first and largest global alliance of privacy and cybersecurity experts from all over the world. It's a community that was launched only in 2018, but is steadily growing. And now we went beyond 50 jurisdictions represented in our alliance, and we are very pleased for that. So I invite everyone to follow us, to learn more about our experts by visiting www.privacyrules.com, and otherwise to register to our newsletters and follow our social media in order to be informed about the various events that we organize. This live webinar is one of them. We recently started with live webinars. This is the third one, in fact, and we are, of course, very pleased for that, in particular because we have a special guest today with us, Susanne Lie, who's a senior legal advisor from the Norwegian Data Protection Authority. We were very happy for Susanne's acceptance of our invitation, because obviously we want to discuss with our members, but definitely with external representatives, in order to learn more the various aspects of the topics we debate. Obviously, we debate something which is probably the hottest topic in this moment, along with, of course, the concern with the pandemic. And I take the chance to express on behalf of all the members of Privacy Rules our sympathy for all those that live in countries which are particularly affected by the spread of the pandemic in this moment. And we join the invitation of the authorities to take all precautionary measures in order to be safe yourselves, your colleagues, your families. The topic we discuss is related to the tracing apps for COVID-19, for positive patients and for people that are in close connection with patients that were tested positive. It is a very sensitive topic because it goes into our daily life, which is actually telecommunications. So any device that we bring along with us in this moment might be tracked willingly or unwillingly. So this is definitely an issue that concerns all of us. I would like also to give the warm welcome to our panelists, starting from Kelly Dixon from Macpherson Kelly law firm in Australia, who accepted to be also moderator of this panel. Australia is a country where the tracing app has been generally welcomed by the population. So I would say it's a non-contextual situation, and for this reason it's interesting to learn from the perspective of Kelly how this was achieved. We have with us also Ruth Ng from Singapore, from Taylor Winters Via, the law firm in Singapore. And Singapore, as we know, is the country that first adopted the tracing app. So it's particularly important also to learn from the experience from this specific jurisdiction. We have Haim Ravia from the law firm Per Cohen in Israel, where definitely to the contrary, the tracing app it's quite controversial for a variety of reasons, including fundamental rights. So it's remarkable to learn from Haim. And eventually we have Gert Sommers from Timelex law firm in Belgium. Gert and his law firm are regular advisors to the European Union institutions on privacy-related matters. So it will be very, very useful to learn the Belgian experience, also because Belgium, unfortunately, is one of the most affected countries in Europe, considering the ratio between the population and the number of positive patients, and in general, the broader European perspective. I don't want to take much more of your time. I want to immediately pass the baton to Kelly, thanking Kelly again for accepting to moderate, and I will say a few words in the end, where there will be a Q&A session. So I invite everyone in the audience to please join us and continue and submit the questions through the Q&A function at the bottom or the right of your screens. Thank you very much, everyone, and in particular to our special guest, Susan Lie. I invite everyone to introduce themselves as well when you will take the floor. Thank you.
Thank you, Andrea. And welcome everybody. It's my pleasure to be joining you. For me, it's this evening, today for a lot of you in relation to speaking about tracing apps. Our topic today is going to be about how the tracing apps have been developed in different countries, how they operate in different ways as well, and what the public reception has been like in relation to those apps as well. We're particularly going to also look at the key priorities and concerns that the various data protection authorities have in relation to how we can really balance what can be quite a precarious and an often very controversial balance between the rights of individuals and the wider and broader public health concerns that an issue like this pandemic can bring about for us as well. I'd also like us to spend some time today speaking about what the future might hold in relation to the development of these various apps. And I know that Chaim is going to tell us a little bit about some of the immediate developments that are happening as we speak in Israel. I can also certainly tell you from the Australian perspective that we are starting our second wave of sorts. Australia, I know, has been very fortunate in relation to a lot of other countries in respect of the number of cases that we have had and the fatalities and all of those other types of issues. But that being said, particularly where I live in Melbourne, in Victoria, we have had quite a large increase in cases just over the last 2 weeks. Day on day, the cases are getting bigger here in Australia. So for us as well, as of tonight, various parts of Melbourne are also returning to our lockdown in a move to try to combat what is happening here and try to make sure we can keep the cases as low as we can. So Australia has certainly been very fortunate from that perspective, and like Andrea, I do extend my thoughts and concern to all of our friends and colleagues and communities that are impacted very, very badly in relation to all of this. So Australia does have a tracing app for COVID. Ours is called COVID Safe, and it has been largely modelled on the app that is in place in Singapore. So Ruth, I'm very interested to hear about what your experience has been, because we've certainly drawn from that here in Australia. Our app here is a Bluetooth-based app. And as Andrea said, it has been accepted relatively well in Australia. I don't know whether that is perhaps a little bit due to some apathy by some of our residents here in Australia, but it certainly hasn't been the forefront of our news and our advertisements in relation to privacy. At the moment, we've had about 6.5 million people who have downloaded the COVID Safe app in Australia. Originally, the government was looking for at least about 10 million residents to download it. So we're not at that yet, but it certainly hasn't been as controversial in Australia as what you'll find out it has been in some other countries as well. So we'll get into this discussion. As I said, I'm really looking forward to hearing about these different perspectives. First of all, though, I'd also like to extend our thanks to Suzanne for joining us as well. We're very pleased and privileged that you can join us. And so I'd like to start with you. If you could give us just a bit of your feedback and your insights in relation to how the DPAs would go about assessing the framework of a COVID type app.
Yes, thank you so much for inviting me. I'm very honored to be invited as a special guest. And on behalf of the Norwegian Data Protection Authority, I'm happy to present our perspective on both the Norwegian contact tracing app and also privacy in this context. Here in Europe, we're not part of the EU in Norway, but we're part of the EEC cooperation. So we also have applied the GDPR. So that's the legal framework which we start our control of this app. And also the EU Data Protection Board has given some quite detailed regulation concerning contact tracing apps specifically. So when it comes to the legal basis, we have quite a bit to work with. And also, we have applied the European Human Rights Convention, which is part of Norwegian law. And also the right to privacy is a constitutional right in Norway. So this is the legal basis for our supervisory activities. That being said, privacy is not an absolute right. It has to be assessed in relation to other basic human rights. This can be, of course, a right to life, a right to health, the public health in general. So this is a difficult balance, I would say. And this is also where we as a data protection authority can do these complex weighings on behalf of the population in general. Here in Norway, this Norwegian app is also based on a specific regulation that was decided when the COVID pandemic was starting to become a real problem here in Norway as well. So we have a specific regulation for the app, but then again, we have to make sure that the app per se is also compliant with other basic rights of the individual. So that's the background of our work. I'm not sure if you want me to go into details about our supervisory actions straight away.
I'd be happy for you to do so.
Yeah, yes, because this app was launched in mid-April. I think the work with it started in mid-March. So this is a very speedy process. Within a few weeks, this app was developed and ready to launch. And since no countries in the world, from what I understand, really have experience with such technology, it's all really starting from scratch, from what I understand. So this also is a risk in itself, of course, that you have to develop something new within a short amount of time. But by mid-March, we were seeing the pandemic fully hitting our societies. So the work with the app started, as I said. And when the app was launched in mid-April, we fairly quickly started our supervisory actions towards seeing how the app was, what assessments it was founded on, the choices that have been made for different technical solutions, etc. An important background information about the Norwegian app is that it's not solely a contact tracing app. The app also has a second purpose, which is to analyze location data so that you can track an aggregated level of population movements and also see if the infection spreads differently in different regions, etc. So that's what makes the Norwegian app quite unique, at least in a European context. So, but today we're going to talk about mainly the contact tracing purpose, so I'll try to just stick to that. Yes, and also with the Norwegian app, it has been said by us and by Amnesty and others that it's the most intrusive app, can only be compared to countries like Kuwait and Bahrain. That's Amnesty's statement. The reason for that is several choices that were made when making this app. First of all, like I said, it has two purposes. It's contact tracing, but also analyzing aggregated data based on location data. But location data is also used in the contact tracing, which differs from a lot of other countries. And also this deviates from what the EDPB, the Data Protection Board in the EU, has recommended. Many other countries, as Australia does, uses their contact tracing or bases it solely on Bluetooth data. Secondly, we have a fully centralized approach, which means that the individual's unit, the cell phone, once an hour, it will continuously send data to a centralized cloud-based storing facility, where data could be stored up to 30 days. This has later been reduced to a maximum of 10 days, but for the first 2 effective months of the app, all data was centrally stored for 30 days. Also, coming back to the 2 purposes, the user who decided to download the app, of course, perfectly voluntary, they had to accept kind of all or nothing. You couldn't choose to only give up data for the contact tracing purpose without at the same time giving up data for the analysis purposes. So that meant that in total, the government would collect an enormous amount of data continuously from what were up to 1.5 million users at the most. However, after being launched in mid-April, we saw that the user number decreased steadily. So after 2 months, the number of users was down to under half at almost 600,000, which consists of about 14% of the population over 16 years, which was intended users. So that's a very low support in the public. One major problem for us as a supervisory authority was that when the app was launched in mid-April, it was still in the testing phase, so that the central technology was not in place. And some of it is actually still not in place, although it's not functional as of today. I'll get back to that, but the whole point of the contact tracing is to give automatic alerts to individuals who have been in close contact with an identified infection. And this alert system was not in place. And by early June, it was still not in place. It was still in the testing and validation phase. There were some problems with the algorithm because of low testing numbers, etc. And for the first 2 months, they didn't have the anonymization solution in place. All data for analysis were supposed to be anonymous, but when you can't anonymize the data, you can't analyze them. So for the first 2 months, the app collected a large amount of data of all the users without actually having the functionality to make use of the data. So this is part of this is a main reason why we see this measure as disproportionate. Because as we see it, the intrusion of the privacy starts when the data collection starts. It's not when you use the data further, it's when you collect the data. So we had a massive intrusion in privacy. There's a wide agreement in Norway that such an app is a grave intrusion to the privacy. And then again, we could not see any usefulness in the other end for the population. So that's where probably our main point of critics towards the app. Also, we were specifically critical to the fact that the purposes were not separated, so that the user had to be part of the contact tracing as well as the analysis. You could not choose to be part of just one or the other or both. Also, the use of location data is deviating from, in the contact tracing, is deviant from what many other countries do, and as well as the EDPB recommendations. And also, we have seen the recommendations from the World Health Organization, and yeah, we see that use of location data is not deemed strictly necessary in our point of view. So our decision was the 12th of June, we gave an advance notification that we would consider giving a temporary ban according to the GDPR on the processing of data in the Norwegian app. And after receiving this notice, the Norwegian Institute for Public Health themselves decided to cease all data collection and delete all the collected data. So this is where we stand today, and we are currently in the Data Protection Authority. We are in the process of making a formal final decision as to whether to temporarily ban the processing of data or not. So we will see what happens. We know that the National Institute of Public Health are currently also working on seeing how they can make changes to the app so that it will be in better compliance with the GDPR. But this is, like I said, an ongoing process.
That's fascinating. We can already see the differences that have occurred in the Australian experience versus that in Norway. Thank you, Suzanne. Ruth, I'll turn to you. With your Singaporean app, the Trace Together app being the first one, can you briefly tell us about what some of the similarities and differences have been in the development of your country's app as opposed to what we've seen in Australia and in Norway?
Sure. Hello everyone. I'm Ruth from Singapore. I'm with Taylor Business Buyer. The Trace Together app was released in Singapore on 20th March. It is similar to Australia in the sense that it functions using Bluetooth technology. It, the user downloads it on their phone, and what it does is it only requires the user's phone number and their identification number, their national identification number. And this is the only information that is collected and stored by the government. And what they do is that they assign a temporary serial number to each app. And this actually gets changed regularly so that other third parties can track the exact number to each device. And what the app does is that it actually keeps record of all the other devices that are within your close vicinity for I think about half an hour. And it keeps all this data within the phone itself. So this information actually does not go back to a central server, which I think may differ from the Australian position and also from the Norway position. So the data is only extracted from the phone when a user is diagnosed as COVID-19 positive. And then that information, when taken by a small number of authorized government personnel, will then be used for contact tracing purposes, where the other devices owners will be contacted. So the information in the phone itself will be stored for 25 days. I think that slightly is closer to what Norway's original storage timeline is, and the government has justified it by saying that incubation period is 21 days, and that's why they need about 25 days to ensure that for contact tracing purposes, to ensure that whoever you were close to during your incubation period. So that in short how the app works.
And what's the community uptake been like? So
as of early June, it was about 2 million. So about 2 million active users, so about 25% of our population.
Okay, great. Chaim, I'd like to turn to you now because we've already heard about some serious differences in relation to the approaches in different countries. Can you talk us through the two different approaches that the Israeli government has used?
Gladly, thank you, Kelly. The first approach was quite similar to those taken by other states, namely the Ministry of Health developed and distributed an app. It's a location tracing app called Amagen in Hebrew. The Shield is the translation to English. It keeps record of your whereabouts. It keeps everything on your local telephone. It uses mainly GPS signals, but also Wi-Fi signals. And it was distributed, I believe Israel was one of the first nations to develop and distribute such an app. At the height, approximately 1.5 million people downloaded and installed it on their devices. Yet it was reported to the Knesset about a month ago that less than 9,000 had kept it. The reason was that it had false alerts. It provided false alerts. It had difficulties because it was a young so-called technology that was very quickly distributed and released. And there was a bit of mistrust towards that, even though privacy was designed in the system. It provided nothing to the government. Everything was done locally. And even if you got an alert saying that you were in the vicinity of a COVID-19 patient, the government did not know that you got the alert. What the app did is that it downloaded the data from the government servers and then cross-checked it locally on your device. So that's one path. But Israel actually took a very different approach than any other state, and that is Israel authorized the internal service agency to trace, using cellular data, to trace the whereabouts of COVID-19 patients. In March, amid the fight against the proliferation of the coronavirus, the Israeli government promulgated emergency regulations directly the Secret Service, known in Hebrew as Shabak. It's an acronym for the Shabut HaBitachon HaKlali, the General Secret Service, to use mobile network location data to monitor the whereabouts of individuals diagnosed as having COVID-19. And then later it was substituted with a decision by virtue of the law governing the operation of the secret agency. And it provided that Shabak may act upon a government, the law provides that Shabak may act upon a government decision backed by an authorization of the parliament to preserve and promote the essential state interests pertaining to national security. And by virtue of that section, the Secret Service was authorized to act in assistance to the Ministry of Health in tracing the patient, the movement of patients and whom they met with. The Secret Service cross-checked the whereabouts of individuals, as I said, who tested positive for coronavirus, and it traced individuals whom they met with in the 14 days prior to being diagnosed. The resulting list of individuals is disclosed to the Israeli Ministry of Health. And those individuals were sent with a text message ordering them to remain in quarantine for 14 days. So that's about it. It was, I will later probably elaborate on that, it was annulled by the Israeli Supreme Court. And as we speak, the Israeli parliament is deliberating reenacting it into law. This reenacting, or the law is supposed to take effect today, because Israel is going through a second wave of coronavirus these days. As we speak, yesterday about 700 people were tested positive for having the virus. So we're living in you know, I'm dealing with privacy for 25 years now, and I don't recall such dramatic times in Israel. Privacy.
Absolutely. Things are moving very, very quickly, and obviously, you know, the data protection authorities and the governments are needing to work with businesses, with individuals, to make sure that the right approach and an approach that I guess is the least controversial is being adopted. In relation to that, Gert, I'd like to pass to you now. Can you explain to us a little bit about the Belgian Data Protection Authority's recommendations in relation to legislation that would permit the processing of health data like this?
Sure, of course, Kelly, thank you. Well, in the beginning, Andrea said that Belgium is heavily affected, which certainly is true to an extent, but it also, of course, depends on the counting model. But even if we are heavily affected, we see that data protection is very often a blocking factor for any measure being taken to fight COVID. So notwithstanding the seriousness of how we are hit, anything we do has to be GDPR proof, and the Data Protection Authority is showing its teeth. Just even a bit over a week ago, Brussels Airport is doing contactless temperature measuring, but the Data Protection Authority didn't like that this was taking place. We'll come to that later. Maybe first something about the apps in general. So Susan also said that there has to be this balancing of interests, which of course also the Data Protection Authority wants. That being said, we have been involved in one of the first, what had to be one of the first national apps, or the app to go in Belgium, developed by one of the main universities and its researchers. They wanted to use location data because location data are considered to be the best from an epidemiological perspective. However, there was so much criticism that this app didn't further develop. And the criticism that we see now from healthcare professionals is that they say, okay, you do this weighing, this balancing of interests between health and personal data, but you see data only as a personal good, whereas they also would like to see it more as a public good, as a data solidarity, so to speak, between citizens. But so far, the case is that, contact tracing apps are perceived also by the population as something very difficult. Even just the obligation to leave your contact data in a bar because we can go have drinks again since a couple of weeks. And sometimes they'll ask you for your personal data so they can contact you later. People are very reluctant to even do that. They will not give it, walk away, or lie. I mean, some people will do it, but just to say how we perceive the whole thing, and knowing that, relatives may be suffering from the epidemic. So that's maybe quite important. So currently there is no COVID-19 app in Belgium. We also don't have a legal framework yet for these apps, but there is a framework in the making. There was a draft bill adopted on, I believe, 13 May 2020. But that was also heavily criticized by the Belgian Data Protection Authority for allowing potential re-identification. The draft bill says that it's okay to allow citizens to know where they have recently been in contact with a person that's infected with COVID, but it's not okay to allow citizens to know who the infected person is, or to store location data, as we said before, because that's something that's going to be a no-go, and also not to keep data in a central governmental database. All centralized storage is a no-go. What else can I say is that these apps are all based on the DP3T system, or they should be based, which is the decentralized privacy preserving proximity tracing technology. Seems to be the protocol, by the way, that is adopted for most corona apps in EU countries, meaning that you should only store completely anonymous data on users' smartphones. It should be open source and decentralized. And again, also what has been mentioned before, the 3-week, 21, 25 days storage period and no longer, which is considered from an epidemiological perspective to be sufficient. And I understand even in Australia, this is the case. And of course, the data have to be protected very, very well, and there has to be a strict management, access management procedure in place. And last but not least, the app can never be obligatory, so it has to be voluntary. You cannot oblige someone to install an app. And it can also not be that if a person refuses to install the app, that the person would be punished for not doing so, or be discriminated, for example, by not being able to make use of goods or services because he or she refused to install the app. So yeah, I said the DPA it has heavily criticized this for the risk of re-identification. So we'll see what the final bill will look like. As we are speaking not only for Belgium but also for Europe, it's important to know that there have also been guidelines at the level of the European Data Protection Board already back in April on the use of location data in contact tracing tools. And just recently, 2 weeks ago, the European Data Protection Board also released a statement on the interoperability of contact tracing apps in Europe. And the European Data Protection Board agrees that contact tracing apps may be rolled out as a temporary solution to fight the further spread of COVID, but it reminds that any app should always be effective, proportionate, and part of a more comprehensive public health strategy. So wherever possible, the least privacy intrusive solution should be used, and especially if you can achieve the same purpose. So we see that, you know, for the development of these apps, you really need to perform a very thorough data protection impact assessment before you do so. We actually also had the case of a multinational client who wanted to roll out a contact tracing app that was developed in the US, and they thought they could just, you know, use it in Europe, but unfortunately, there's different perspectives on these things, so they had to put the European rollout on hold.
And I think that Australia would perhaps fall into a similar sort of category as well. Our level of privacy protection is not yet at the level of restriction that exists in the GDPR and the EU countries. So that's fascinating that you've got to work within those restrictions as well at the same time as trying to handle what is a huge public emergency in relation to the health of all of the global citizens.
Yeah.
Andrea, I'll pass to you now to mention about the interview that has been publicised.
Yes, thank you very much, Kelly. And actually, I take the baton also from Gerd to underline how important it is to rely on an alliance like Privacy Rules. So you can see that there are so many different perspectives internationally. And it can be very well that one company wants to launch some similar service in another continent and bump into a so-called privacy wall, and therefore needs perfect professional timely advice from experts from that specific jurisdiction. No, what we have heard so far, it's very interesting because we see that the pandemic is a global crisis, but there are so many different approaches. I want to take just quickly, thank you, Kelly, for this. I want to mention the interview that we just released actually 2 days ago to Bae von Seok, who is the Director of Development of Taina 3D, which is a technology and entertainment company which developed the application for South Korea. I believe that that application, together with the experience of Singapore, is among the most debated ones internationally, not only because I believe it came as a second, but also because it was very effective. And I invite everyone to visit our website. So the interview is published there. It's right on the homepage. An interesting element is that despite the fact that this company has been interviewed even by major outlets like CNN and Foreign Policy and Forbes, there is a lot of disinformation out there because everyone was saying, this application actually extracts personal data without the awareness of users. This is not the case, actually. This application simply uses publicly available data disseminated by the South Korean government. And it was not the South Korean government to ask this company actually to develop the application. The company decided to make the application on the basis of data already available there. So it is very important to look at these information related to tracing up, also to properly understand how these applications are developed and can be used. And so I invite everyone in the audience to see, to read our interview and to follow even these webinars because they are very important for that purpose, actually, disseminating independent and accurate information. Thank you very much, Kelly, for this. I pass it back to you.
Thank you, Andrea. I wanted to turn back to Gert and to Suzanne at the moment, just in relation to the restrictions that you have in relation to the current laws, and given that in your jurisdictions there has been a real pushback in relation to the adoption of COVID tracing apps, what are your views on what the alternatives are to the tracing apps, and how effective do you think they are? Suzanne, I'll start with you.
Thank you. I think you're onto something with the last thing you said. How effective are they? And that can obviously depend on how they are set up. From what we hear, Singapore and South Korea have achieved successful contact tracing. However, with the technology used here in Norway, we are still unsure whether precise contact tracing is even possible. The National Institute for Public Health, part of the reason why they chose to use location data as well as Bluetooth data was to achieve a higher level of precision, because Bluetooth data alone has its weaknesses and location data on its own is not precise enough. So by combining these two, they're trying to achieve a very precise contact tracing. However, they see that even with using that intrusive measure, it's difficult to be sure that you're alerting the right amount of contacts, not too many, not too few, because having too many false positives, that means people who are believed to be in close contact with an infected person, but who are really not, and having them quarantined is not desirable either. So I think as of today, we still have problems with this, or with knowing whether this can actually be an effective measure or not. But as a data protection authority, we have been very, we have tried to state that we are not opposed to digital contact tracing in principle, but it has to be an effective and proportionate measure. And that's where we see today that it is lacking.
Gert, what about for your citizens in Belgium? What's the feeling about the trade-off between personal data protection, the right to privacy, versus the benefit that can be for public health?
Well, it's difficult to speak, of course, for the general Belgian, with how they feel about that. But as I said, I think there's most people are very reluctant to installing an app and trusting, what will happen to the data, who will handle the data. And I think I understand why. I mean, I'm looking at this from a privacy perspective, not from a healthcare perspective myself. I understand also the criticism from healthcare professionals, because they, from their perspective, they know or that data will only be used for that purpose. But then again, we also know that there are a lot of data breaches in this world and, data being misused. So there's always that potential. And that's why any centralized storage of data should, in my opinion, also be done in a very careful way. So what is the trade-off? Yeah, I mean, it's in the end, if it's up to the government to come up with this law to provide for a framework, and then any app should convince citizens that it's okay to install it. It should be audited, and the necessary guarantees have to be provided. I think then it's possible. Maybe even myself, I will install it at some point. But again, as I said, it has to be voluntary. So that's, I think, the main trade-off. But of course, there's also other measures. There is not only the app. Well, there is the app in the private sector, which I think can be used maybe more easily than a national app. And at national level, you can only have one app. It's very difficult to have many apps, so there has to be the app to go. But yeah, of course, we have now our general measures and bubbles and mouth masks and stimulating home working. There are a lot of other measures being taken that also help to mitigate the effects of this crisis.
Chaim, over to you. You've been mentioning that right now the government is looking at some legislative backing in relation to the COVID measures in Israel. Can you expand on those for us? I think they're amazing.
Yeah, well, I'll begin with the background. The Supreme Court of Israel had heard a case against the surveillance of the Secret Service, and on, I believe it was April 26th, a decision made by the court invalidated these emergency steps that the Israeli government was taking. And the Israeli Supreme Court held that while tracking the whereabouts of individuals may be necessary to combat the coronavirus pandemic, the means utilized by the government were extreme. First, the government was taking to the extreme the interpretation of the law governing the authority of the Secret Service. Such measures may have been justified in really emergency cases. That was the case when the pandemic first broke. It was an unusual emergency case. There were no alternatives at hand, etc., etc. So at that point in time, it may have been justified. But considering the fact that it is the Secret Service surveilling citizens, and that privacy is a constitutional right in Israel, then it should be a decision of the Israeli parliament enacted as a law. Hence, the government beginning June 8 have withdrawn the use of surveillance measures by the Secret Service, but due to the second wave that we are going through these days, they had to reenact or actually to enact a law authorizing the Secret Service to re-engage in assisting the Ministry of Health through tracking the whereabouts of COVID-19 patients. Now, this was deliberated in the Knesset during the last week, and it will be voted within minutes or the next few hours.
Exactly, it's happening right now.
It's happening right now. It is anticipated that the Knesset will approve the measures. They will be in force until July 22nd, which means for 3 weeks. And then during this time, a more balanced arrangement will be discussed and enacted. This more balanced arrangement should be in effect for 6 months, but in Israel we have a saying, nothing is more permanent than the temporary. So we assume it will be in place until the pandemic will disappear.
Great, thanks very much for that. We are coming towards the end of our time together, so I do hope that for our audience you are submitting some questions that you would like to ask the panelists that we have today. While you're thinking of those questions and putting some of those through, Ruth, I'd like to finish up with some questions to you. And I'm aware that in early June, the government announced in Singapore that it was perhaps planning to roll out a wearable device as opposed to using an app that is related to someone's personal mobile telephone. Can you tell us a little bit about the progress of that, how that is being perceived by the public, and also probably whether you think that that creates a bit of a slippery slope to other types of devices as well?
Sure. Maybe I'll start with sharing a bit of the background as to why this token device was being developed. Firstly, as many of my fellow panelists here have highlighted, Bluetooth does have its limitations. One of the problems that our government faced was that Apple or iOS phones would actually disable an app that uses Bluetooth in the background. So Apple phones that had the Trace Together app would not actually function if it wasn't the active app that was open. So that actually greatly limited the purposes of the Trace Together app in Singapore, and it was a huge problem. What the government felt was that if we created a token, if you Google it, actually the first batch was released 2 days ago. It's about this size, and it's been given to our vulnerable seniors in Singapore. This token is supposed to function in the same way as the app. It doesn't connect to the internet. It only uses Bluetooth, and it actually just keeps all the data on the device itself. It's only when the user, the owner, is found to have COVID-19 will that app actually be taken by the authorities and data extracted to see what other devices in its vicinity were in its vicinity for about half an hour or more. Something that I think should be emphasized after hearing some of my colleagues is that the Trace Together app, whether on the phone or on the device, do not use GPS technology. So locations of the users are actually not kept. But something to take note, I feel, is that in Singapore, we do have another app called Safe Entry. Most establishments, food offices, hospitals, are now required to use the Safe Entry app. So if you want to go into a shop in Singapore, you actually have to register before you can go in. So there is actually a centralized database in Singapore that keeps track of our locations in a lot of areas. So that has to, our understanding of the Trace Together app has to be seen together with this. That's how our contact tracing mechanism in Singapore works.
Wow, watch this space, everybody. Hey, things are moving so quickly, and there's so many different opinions and legal issues that need to come about in all of this. It is 10 minutes to 7 for me here, so I'm now going to hand back over to Alessandro and Andrea to raise some of the questions from our attendees in the webinar today. From me, I would just like to thank you all for joining us and for listening in. We appreciate your attendance, and for the panelists for sharing your insights and your views in relation to what's happening in your jurisdictions. Again, Suzanne, special thank you to you for joining us. We're very happy to have you here with us. And from me to all of you, wherever you are around the world, I do wish that you and your friends and your communities remain safe. And over to you now, Andrea and Alessandro.
Excellent, Kelly. Thank you so much for your great moderation, and definitely for all of you for these very precious insights in the perspective in your jurisdictions, or in Suzanne's case, actually in your authority, and therefore what's happening in your communities. There is a question. So the first question that is there comes, I believe, for Jaime, but in general for all of you. So I would like all of you, including Kelly, to answer. Are you aware of any other country around the world where the secret services are authorized or given the power in some form for COVID-19 purposes to track information related to citizens?
In Israel, we are unaware of any other democracy that uses its secret service for such purposes. What's happening in China or other non-democratic countries, I really don't know. But what became known due to the fact that the secret service was involved in assisting fighting COVID-19 is that actually the secret service gathers collects information about the whereabouts of all of us all the time by virtue of the law that governs its operations, and that law was enacted in 2002. Now this is if you like, this is a result of the 9/11 events. The Israeli law is, well, it's not the equivalent of the US Patriot Act, but it does give the Secret Service highly sensitive authorities that are being used to track, to monitor the whereabouts of us all. Most of or usually it's being done through technical data pertaining to the movement of cellular telephones, etc., etc. It is done to fight terrorism. You know that Israel is in a constant battle against terrorists, and it is for the first time being used for other purposes rather than be limited to security and national security purposes. This, of course, creates great apprehension, and Israeli public is highly troubled by that. And yet there are no other effective measures in Israel, so the government is, as we speak, trying to reenact the authorization of the Secret Service to utilize such measures.
Thank you. Another question is specifically for Ruth, and the question is: does the app in Singapore use open source or not?
The app itself is open source. Let me send a link to all the attendees and panelists. The government has actually underlined the protocol and has released a white paper on the app, and it is actually open source so that other countries can also develop from our technology. So you can refer to that link.
Thank you very much, Ruth. This is very useful. Another question is for Suzanne, and the question is, would you consider the Norwegian approach, I believe, proportionate if data was used and effective? Or, sorry, the Norwegian app, proportionate if data was used and effective?
It's of course difficult for me to give a definite answer to that in retrospect, but we absolutely accepted the app from the get-go because we were in an acute crisis as a society, and we deemed it that it could be a proportionate and appropriate and effective measure. However, our CEO actually stated that we would not allow such an app in a time of peace, referring to the measures in society were the strictest since World War II. So that states a bit about how we actually assess this as an acute crisis. But in a crisis situation, of course, we could have definitely accepted an intrusive measure if it proved to be useful. A part of the problem after some time was that the support in the population started to fall, and also the infection situation has been such that we have a very low number of infected people here in Norway at the moment. So if the app would have been effective in such a situation, it's difficult to say. But effectiveness or usefulness, as well as the proportionality, has been central in our assessments.
Excellent, Suzanne, thank you very much. And there is another question, probably the last one we can take here to try to remain on time. And actually, I believe this is the elephant in the room. So I thank very much our colleague Farouk for asking this question, because the question is there a possibility that these kind of applications will outlive the pandemic? In other words, actually, what comes next? Have we opened the Pandora box because of the apps, for these kind of apps? And in the future, governments and authorities will find other excuses to use them. And what's going to happen to all this data? I think this is definitely an open-ended question, but what's your feeling? I believe that many of you expressed very personal views as well. Like Gerd was saying, the population simply lie. If I can make you a comparison, a very banal comparison, I believe it's like the non-possibility to smoke in public places or wearing the helmets while driving a motorbike. Until the authorities were enforcing these kind of measures, nobody was following them. Now, actually, privacy rules members have a mandate to try to spread the proper information about privacy, I believe. And actually, where is the right strike and balance between privacy and public safety? So what is your opinion, the opinion of all of you concerning what's coming next? And I believe it's opportune to give the floor again to our special guest, Suzanne. Suzanne, if you're
Thank you. I actually have some thoughts on this. I can just state that the specific regulation for this app, it has a time limit to it. So it will cease on the 1st of December this year, if I remember correctly. However, there is always the opportunity for that regulation to be prolonged. But as a data protection authority, we would then see that as a democratic society, this should be regulated by law. If this is a measure that is supposed to last over time, by then it's a guarantee in itself to be part of the democratic process that giving a law is. What we're concerned about as a data protection authority is, first of all, the population being accustomed to being supervised. If we accept this in a state of crisis, what will be in the next crisis to come? So there's that, and there's also what we refer to as a cooling effect, where people are becoming wary of the data that they share, just because they're gaining a mistrust in how their data is collected and used. So there is a very much an overreaching perspective here that we try to try to look at in our work.
Excellent. Thank you, Suzanne. Kelly, I think you might
I think it's fairly similar for us too. A lot of the COVID measures in Australia have been restricted by particular sunset dates or end dates in relation to that legislation. As I said earlier, the Australian approach, and we cannot speak for everybody in Australia, but it does seem to have been less controversial in Australia than it has been in many other countries as well. But it will be interesting to see, I think, just where the Australian laid-back nature may come to an end in relation to what might be next and the level of supervision that the citizens here have.
Is there any other thought on this in the room from Haim, Ruth, or Gert?
I'm afraid that Western governments will learn the usefulness of monitoring the citizens constantly, and they will be addicted to it. So time will tell what happens with that, but I would be very cautious. We're beginning to understand the power of mass surveillance and the benefits to governments from that. And I would be very cautious. We will be facing challenging times, at least in Israel, but I suspect that in other countries as well.
Thank you. So thank you all. I believe that this brings us to the end of this very interesting live webinar. Once more, on behalf of the entire Privacy Rules Alliance, I would like to thank warmly Suzanne for accepting our invitation today. Actually, probably you made a mistake because you will receive other invitations because your perspective was so interesting, open, that definitely we would like to learn more from you. Also from a country which is not literally part of the European Union, but yet applying part of the European Union framework. So that was really inspiring for a variety of reasons. And to all of our members, from Australia, Kelly, Ruth from Asia, Ger from Europe, and Haim from Israel. If I can mention here before we close this session, we will continue with airing live webinars. Again, COVID is one of the topics in this moment. So the next one we are going to have in the coming weeks, and we will promote this through our channels, will be related to privacy in the air transport sectors, exactly for the reasons that we were discussing now, because that sector is severely affected economically, of course, because of the closures and restrictions, but actually many different countries are imposing different measures. So that would be interesting to discuss. Gert, if I'm not mistaken, for instance, mentioned the possibility or non-possibility of testing temperature of travelers. So there are a lot of implications also on tourism for a variety of reasons. So we will debate these also with data protection authorities from overseas, and also with airline companies and airport data protection officers. So there will be these various perspectives on this interesting topic. And then another topic that we will debate in a live webinar will be related to contactless temperature measurements specifically, and how all these data accumulated can be stored and processed in various countries. This is a general invitation to everyone here to, as I mentioned before, to subscribe to our newsletter and follow us on social media to learn when these events will take place, and therefore continue following us. I apologize if these live webinars are sometimes in moments where it is difficult to be still awake or to wake up, but this is the beauty of being an alliance spread so around the world. We will have another event with our Chinese colleagues on the 8th of July, but there will be some kind of limitation to attendance because of number of seats available, but they will be specifically related to data breach management, which is one of the areas where Privacy Rules is working in particular. I will close here, thanking a lot again all our panelists. Suzanne in particular, as I said, and Alessandro, who didn't say anything, but he is one of the key masterminds behind the privacy rules and the management of all these experts. So thank you very much once more, and we hope to see all of you soon again on our channels. Thank you and stay safe.
Thank you so much
Bye-bye.
for having me.
Bye-bye.
Bye.
Thank you.